Welcome to Primetime Crime Live. I'm Jarret Ferrantino. I'm solo this week. Lauren is on assignment in Oklahoma, and for those of you that are following her tweets, you know she's covering the Gods Misfits preliminary hearing. We will be back together on Monday, breaking down the events of that proceeding and the latest developments in that case. I did not want to miss a week of giving true crime updates and really what's been going on in the true crime world. Certainly Luigi Mangione is a huge deal. P. Diddy has withdrawn his request for bail. We've been predicting he ain't ever getting bail since the minute those charges were lodged. And I wanted to give an update on the latest developments in Idaho in the prosecution of Brian Kohberger. Mangione has kind of taken the forefront of the press off of the focus on the Kohberger case, but there have been some significant happenings in Kohberger land over the past month or so, and particularly the past week. That case right now, as we all know, is in pretrial litigation. It's a time when the charges are pending, discovery has been provided. Those terabytes of information that were collected in the investigation have long since been provided to the defense. The defense has begun the process of sifting through that information. And as they are doing it, they are lodging their defense. And they are really telegraphing their defense through their pretrial motions. As a prosecutor, you fully expect these challenges. As a prosecutor who's done death penalty cases, you're going to expect really certain challenges to the death penalty that will be forthcoming. And they did come in the Kohberger prosecution. Kohberger's lawyers have challenged the death penalty by firing squad in Idaho. That's how you're killed in Idaho. If Brian Kohberger gets the death penalty, he will be put to death by the firing squad. So how does that play out in pretrial litigation? Here's how. His attorneys have filed challenges to the constitutionality of the death penalty. They said a couple of things. Number one, it's cruel for a prisoner to sit in jail after the execution penalty has been imposed by a jury and then lie in wait as their execution is pending. Now think about that, folks. Execution is a punishment. The defense is saying it's cruel to know that that punishment is coming. All the while you're sitting in that jail cell, your attorneys, paid for by the government, are allowed to challenge that sentence against you. There are also other unique challenges that were made to the death penalty in the Brian Kohberger case. His attorneys have said, hey, international law bars the torture of prisoners. And the judge looked at them and said, wait a minute. We have international laws that apply to prisoners. Yes, you cannot torture them. But the judge, Judge Hippler, the new judge, not Judge John Judge, our old judge, we're in Judge Hippler's world in Ada County, Boise now, since the case has been removed. He says to the defense, hey, I get you're saying international courts and international law say you can't torture prisoners. That law is really a due process law that says you cannot impose punishment or imprisonment without a finding or a proceeding regarding the charges that you're facing, and that's due process. So Judge Hippler has said that wouldn't have applied. The fact that you're claiming it's cruel to await your execution, that challenge has been rejected. The other challenge they've made is that it's cruel and unusual punishment to face the firing squad, that it is offensive to the morals of our society and decency that the society we live in could impose the death penalty. These are all challenges that have been made in Idaho and across the country and have not really been overturned as a result of those challenges. So essentially, prosecutors seeking death have been able to keep those challenges at bay. So you may say, Jarret, why would the defense attorneys even be making these challenges? Why, when they know they're going to be unsuccessful? Two reasons. Number one, appellate courts surprise you. The law may change. Different judges look at particular cases and see different things. If the Constitution and the application of the Constitution have remained the same throughout history, We wouldn't have any need for lawyers. We wouldn't have any need for courts. So these challenges, although somewhat predictable, aren't made in vain. They could be considered and they could be overturned. Number two, if you don't make these challenges and your client gets the death penalty and is ultimately put to death and you fail to preserve these challenges, they cannot be made at a later date. They have to be made at the trial level. So this is lawyers doing their jobs and protecting the record and their client. You may not like it, fair enough, I've said it before. You may not like the fact that Brian Kohberger's lawyers are working very hard for him. I've always looked on the other side at defense attorneys that are working hard for their client. I'm happy to see it because I know the harder they work and I was able to get a conviction, that conviction will likely stand the rigors of appeal because their lawyers fought like hell for them. And that's our system, folks. As we know, Brian Kohberger is innocent until proven guilty. I've never shied away of my ultimate opinion on Brian Kohberger's guilt. I think he's guilty. I think they got the right guy. Doesn't mean this case is a slam dunk. As a prosecutor, I've also said I can't stand that term, slam dunk. You think this is a slam dunk? This is a 6-7 month trial. You're going to have experts out the ass here. There's going to be hundreds of experts and expert reports. Nothing about this is a slam dunk. This is going to be very complicated and a very heavy lift. So in addition to the challenges of the death penalty, so newsflash, they've been unsuccessful. Brian Kohberger is still facing the death penalty. In addition to those challenges, we're going to see a wave of what we call omnibus pretrial motions. And what does that mean exactly? Now, the defense is going to be trying to suppress all of the evidence that's been gathered against Brian Kohberger. And what's been gathered against old Brian Kohberger at this point? We know the DNA that was taken from the sheath itself, the cell phone information, the fact that he was driving the white Hyundai. He was searched himself. DNA was taken from a buccal swab of the inside of his cheek. These are compelling pieces of information that have been gathered in this prosecution. That's the stuff we know about. There's also a host of evidence that's been gathered electronically through his Amazon account, through his Google account, through his Apple account, through his AT&T cell phone account. That information is not contained in the affidavit of probable cause in great detail, and some of it has been garnered since then. Interestingly, that information remains a mystery to us because anything covering those particular items remains sealed. In the Commonwealth of Pennsylvania, where I have predominantly practiced and prosecuted death penalty cases, I haven't sealed information like that. Omnibus motions have been just a great treasure trove of information of how details of a case come forth in the filing of omnibus pretrial motions by the defense and the responses of the prosecution. The only time I've ever really danced around confidentiality and sealing particular pieces of evidence is if it would out a victim of a rape or a confidential informant. So it's curious to me and kind of a new experience for me to see all this secrecy on both sides of the Kohberger prosecution. Remember one thing, they're trying to suppress the data that was and evidence that was collected from those electronic devices and those companies. Why? Because number one, there's probably some good stuff in there and they're trying to get it suppressed. And number two, anything that you think could be used against your client that you believe was collected in violation of your client's rights, you're going to ask to suppress. But what does all this legalese mean? What it means is this. In a nutshell, here's what Brian Kohberger's attorneys are saying. They're saying the probable cause, okay, the information that you used and wrote out and swore by and took to a judge, had a judge sign it, on a search warrant and then execute that search warrant is defective in this case. And if it's defective on one search warrant, it's defective on all of them. They call it the fruit of the poisonous tree because as prosecutors, we use the same warrant as we continue to move through a case, add the information we get, but the foundation is the facts that we've established in the beginning and through the investigation. What is being said? There's a couple things the Kohberger defense team is saying. They're saying one thing is that the prosecution deliberately withheld information from the judge that was presiding over or reviewing the warrant. Now, folks, you may not understand this because it's not typical in your everyday experience. A search warrant is prepared by the investigators. They're brought to a judge, not Judge Stephen Hippler, not Judge John Judge, probably a duty magistrate, okay? That judge reviews this. This is a neutral party, okay? And for an investigative body to search a home, search a car, search someone's person, they need probable cause. And probable cause is what they think probable cause is, but it is authorized by a neutral and detached judge reviewing the warrant, signs the warrant, and then it gets executed. The defense of Brian Kohberger and his team are saying the prosecution deliberately left out the fact that they gathered Brian Kohberger's DNA or identified Brian Kohberger through IgG DNA. And this is a flawed science. It's a new technology. It does not amount to probable cause. The only reason they focused in on Brian Kohberger was this IgG technology, the family tree that was built on this consumer genetics database. And therefore, if the probable cause and the fact that fingers were pointed at Brian Kohberger were based on IgG technology, the entire warrant falls. That's one argument. The second argument is there was other DNA in the house that was not properly tested. They weren't run up against the IgG technology, basically chipping away at a foundational piece of evidence, which was Kohberger's DNA. How has the prosecution, now them's fighting words, you're saying the prosecution is lying, okay? They have not represented to that neutral judge the entire picture, okay? And they're asking for what's called a Franks hearing. And a Franks hearing basically says the prosecution lied, they omitted material facts, we want this judge to reconsider the evidence with these material facts in, and you will not rise to the level of probable cause. All that evidence is out. Here's how the prosecution has responded. Number one, the prosecution has said, with or without IgG technology, we had focused in on Brian Kohberger. And you may ask, how in the blue hell did they focus in on Brian Kohberger without his DNA? You would remember, they identified a white Hyundai Elantra. There was a be on the lookout for white Hyundai Elantras. A Washington University security officer identifies a white Hyundai Elantra. That license plate is processed. Brian Kohberger is identified. He physically matches the physical description provided by the roommate who saw Brian Kohberger exiting the house that day. So they are then led to Kohberger, led to run his cell phone through the towers, et cetera, et cetera. That is information that led to Kohberger independent of IgG technology. And they're saying whether you go through IgG technology, DNA, or independent, we get to Brian Kohberger and ultimately run the touch DNA that was processed on the knife sheath and then compare it to Brian Kohberger when he's brought in. All fingers point to Brian Kohberger. We're okay. That hearing and that issue will be heard late January. The defense has till December 20th to respond to the latest response of the prosecution. They may respond, they may not. I think the defense has done a good job. This is not to say I think this evidence is going to survive. I think the defense has done a good job at creating a great challenge to this evidence. But I believe that the probable cause that was set forth with the information contained in the affidavit created two independent roads that led to Brian Kohberger. I do believe that the prosecution was well intended and properly established probable cause in those warrants. And that's the warrants for his car, that's the warrants for his parents' house in Pennsylvania, that's the warrant for his person, all of that, and the warrants for his electronic devices. One of the other challenges that they're making are that the requests, like let's just say we are doing a search warrant for WhatsApp on your phone. And they requested, the warrants that were requested in this case were actually to dump Brian Kohberger's entire phone or his entire Amazon account. And what the defense is saying is those requests are so broad and so sweeping that they're beyond the relevant realm of this investigation, and therefore were too broad in their scope and were really a violation of Brian Kohberger's rights. The prosecution in response is saying, first of all, we were not limiting our search to one particular app or one particular area of an electronics device. We were limiting our search to information relevant to this murder. Okay, and that is painting with a pretty broad brush, but I do believe that that challenge will be overcome by the prosecution. I don't believe, I've made those requests. I've made those broad requests in the same manner that this prosecution has made them. They have stood similar challenges. All of this is about, when you say, what's really going on here, Jarret? What is this about? Here's what it's about. A mountain of evidence, and some of you may take issue and say, bullshit, Ferentino, there's not a mountain of evidence against Colberger. Fine. I'll tell you what, I'd still rather be in the prosecution side of this thing. A mountain of evidence has been collected. When you look at this evidence, defense lawyers are saying, was the evidence collected in violation of any of Brian Kohberger's constitutional rights? And this really comes down to, did the investigators have enough information? Have they put that information in front of a judge, and did they establish probable cause to violate Brian Kohberger's privacy and collect that evidence? That's it. That's the big question. I wish I knew the answer. My prediction is this: the evidence is going to remain in. I think the prosecution's okay, and we are continuing to move to trial. Another thing that happened last Wednesday, which was a blurb in a couple of the articles, was the defense met privately with Judge Hippler. And you may ask yourself, what does that mean? Why would the defense team be meeting privately? Are they talking about working the case out? Why would they be able to meet with the judge without the prosecution? Isn't that unethical? In most cases, yes. However, when you have a defense team for an indigent defendant like Brian Kohberger, if there is an issue of funding, if there is an issue about paying for a particular investigator or expert or testing, that meeting would typically happen ex parte, alone, without the presence of the prosecution. So that's more likely than not what that meeting was about. I hate to speculate, but I have been outside in a courtroom when defense and a judge are meeting in their chambers on those very issues. And that's not something that the prosecution would be privy to, because the prosecution at that time should not know what particular experts being retained by the defense, what investigators are doing. It's just, it would be a violation of fairness and the standards of fairness in the court system if that was happening. So that's what was happening in that particular meeting. As we move forward, undoubtedly, there will be even more challenges coming against the prosecution and their investigation. Really, what's surprising to me is how they've managed, both sides, to keep so much of this case under wraps. So many of these filings are sealed. So many of these arguments are shielded from the public because much of the information remains undisclosed to the public to assure Brian Kohberger and the prosecution the right to a fair trial and a fair prosecution. The stakes couldn't be higher for everybody involved here. We're going to continue to watch the Brian Kohberger prosecution and bring you updates as more of these motions come in.